All rise. The Supreme Court of the United States is now in session. Chief Justice Nathan Heck presiding. All who have business before this court draw near and be heard. There is one case on the docket, number 2017-2018, Petitioner DeNolf versus Respondent, the State of Olympus.
Please be seated.
Before we get started, my name is Al Ellis. I'm a community liaison here with the North Texas College of Law. I want to introduce you to who your judges are so you know what I think is the quality of folks who are brought here to listen to this. First, we've got the Chief Justice of the Texas Supreme Court, Nathan Heck. We've got Justice Lang from the Fifth Court of Appeals here in Dallas. We've got Judge Jane Boyle, who is a federal district judge in the Northern District of Texas. We have Judge Tanya Parker, who is a district judge for the 116th Court here in Dallas. We've got Judge Hector Garza, who is a judge of the 195th District Court here in Dallas. And then we have Denise Garcia, who is a judge of the 303rd District Court, and she is a family law judge. So you've got appellate judges, federal judges, family law judges, and criminal judges, and may the best team win. Thank you.
We'll hear argument in 2017-2018, DeNolf versus the State of Olympus. Mr. Engle, we'll begin with you.
Your Honor, before we proceed, Petitioner would like to respectfully request to reserve 3 minutes of our time for rebuttal. Thank you. Mr. Chief Justice, and may it please the Court. My name is Caleb Engle, and I, together with my co-counsel, Christopher Baldacci, represent the petitioner in this case, Mr. William DeNolf. I will be addressing the Fifth Amendment issue, and my co-counsel will address the Eighth Amendment issue. Your Honors, this court in the case of Cologne versus Connecticut, as cited in Von Barry, provided a constitutional guarantee that the state must arrive at convictions by dint of its own independent labors, rather than through the cruel expedient of forcing a confession from a suspect's own lips. It's for that reason that we ask this court to overturn the ruling of the Olympus Supreme Court and declare the FBME facially unconstitutional. To this end, we offer 2 points of argumentation. First, that the FBME is the functional equivalent of express questioning. And second, that the FBME is facially unconstitutional because it is always incriminating, compelling, and testimonial. To the first issue. Your Honors, on page 2, paragraph 2 of the facts of the record, there are provided numerous details as to how the functional brain mapping examination actually operates. You will find that the goal of this, as used by law enforcement, is to discern whether or not a suspect in a criminal investigation has knowledge or memory of being at the scene of a crime. Now, this knowledge is elicited by showing the subject a series of images. While they may begin randomly, they ultimately culminate in actual images of the crime scene. In effect, each picture a subject is shown is the functional equivalent of a question. Have you seen this? Do you remember being here? The subject's brain then provides an automatic affirmative or negative response, which is registered by the test. This court, in the case of Rhode Island versus Innis, explained that the term interrogation refers to any words or actions on the part of people which they could reasonably know would elicit an incriminating response from a suspect. Your Honors, the FBME is designed to do just that. The sole purpose of this test is to elicit incriminating responses from those who are subjected to it.
Does it go to the length of the evidence as to whether it's communication or not, simply because somebody appears to recognize the location? That doesn't mean the same thing as, or does not provide as much information as a blood test, does it? It's substantially less.
Respectfully, Your Honor, the issue that this court has always decided the difference between physical evidence and testimonial acts relying on is the degree to which the test invades the actual contents of the suspect's mind. That's pursuant to this court's ruling in the case of United States versus Doe. So the relevant test is not how much information a piece of evidence may provide, but whether or not that piece of evidence relies on the consciousness of the suspect and the operations of his mind in producing certain facts. And the FBME only functions if the suspect is conscious and if his mind operates.
Sounds like a polygraph.
Your Honor, it is indeed very similar to a polygraph in that it uses physiological responses to incriminate someone. And as this court ruled in the case of Schmerber versus California, to predicate a suspect's guilt or innocence on the basis of physiological responses, whether willed or not, is to invoke the spirit and history of the Fifth Amendment. That's precisely what the FBME
Is it your position that he agreed to this? It sounds like he waived was given his Miranda warning several times and then went along with the officers to submit to the test.
Your Honor, no. The petitioner was actually never formally Mirandized by police officers. And on two separate occasions, page 4, paragraph 4, and page 5, paragraph 1, he explicitly invoked his right to remain silent, informing the police that he would not answer any more of their questions. But moreover, Your Honors, the FBME wasn't just compelled in this instance, it's compelled in every application which the state uses. Now, this court in the case of Heibel versus 6th Judicial Circuit Court of Nevada, as cited in Von Baron, explained that to satisfy any Fifth Amendment claim, the petitioner must satisfy a tripartite test. Namely, we must demonstrate that the communication in question is testimonial, compelled, and incriminating.
Well, let me ask you, was it compelled in this situation since he could have looked away, he didn't have to look at the photograph?
Yes, Your Honor. In fact, the issue of compulsion for the purposes of this court's analysis is whether or not there's being any type of coercion enforced upon the suspect. In other words, if the suspect is unable to make a choice as to whether or not he'll answer yes or no or remain silent to a question that's posited to him, he's being compelled. Compare this to the instance of custodial interrogation. The issue of compulsion in a custodial interrogation is not whether the suspect must sit in the room, but whether or not he's able to choose what his answer to the question posited to him will be. In the same way, the issue of compulsion with the FBME is not whether or not Mr. DeNolf had to sit in the room or have electrodes hooked to his head, but whether or not he could choose to answer yes or no, or choose the silent option.
Was he in custody?
Your Honor, he was not explicitly in police custody. However, this court ruled in the case of Estelle versus Smith that the term custody refers to any instance in which the suspect's freedom of movement has been substantially mitigated by police. And in this instance, the suspect made very clear that he was uncomfortable with the nature and the direction of how the police officers were treating him, which seems to indicate that for the effective purposes of what this court considers custody, he was, for his perceptions, within custody, which is...
Isn't your argument that he was coerced undermined by the fact that the FBME procedure was explained to him, and it was after that that he said he didn't want to answer any questions, but yet he stayed for the test and cooperated with the test?
Your Honor, first, the state had obtained a warrant to require Mr. DeNolf to submit to the FBME. But moreover, Mr. DeNolf, we contend, did not fully understand the implications or the nature of the test about to be administered. The state's technicians informed him that the test was purely procedural, much like taking a fingerprint. Your Honors, let me be clear. There is nothing procedural about a test which is so invasive that the agents of the state believe they need to obtain a warrant to even conduct it. The police officers in the room knew the nature of the FBME and the evidence which it would produce.
But you need a warrant for blood.
Yes, Your Honor, and that's because it's a Fourth Amendment search.
But you're distinguishing the Schmerber case from the situation, correct?
Yes, Your Honor.
As non-testimonial in the Schmerber case.
Yes, Your Honor, that's correct. Our argument as regards to the warrant merely goes to prove the invasive nature of the test which was administered to Mr. DeNolf and the fact that it was inadequately explained to him. In fact, he was the only person in the room at that time who did not fully understand the nature of the test being administered and the type of incriminating evidence which it would derive from him, which makes him quintessentially the diluted instrument of his own conviction, which this court has prohibited.
Even though you emphasize the warrant, is it not true that the officers asked him whether he would go down to the testing and that he voluntarily walked down there and he himself went? It was not under handcuffs or any other situation?
Your Honor, I see I'm running out of time.
You may answer.
Thank you, Chief Justice. Your Honor, Mr. DeNolf, actually, the police officers on page 4, paragraph 4, didn't necessarily ask him. They merely informed him, we would like you to go with us to take a test. Moreover, the issue of compulsion with the FBME is that the subject cannot exercise his will in choosing his answers, regardless of what the specific facts in this case are, which is why we ask this court to find this an unconstitutional violation to the sanctity of the American citizen's thoughts. Thank you.
Any other questions? Thank you, Mr. Engle. Mr. Baldacci, we'll hear from you.
May I proceed, Your Honor?
Please.
Mr. Chief Justice, Your Honors, and may it please the Court. My name is Christopher Baldacci, and I rise to continue argumentation for the petitioner, William DeNolf, on his Eighth Amendment claim. Your Honors, no matter how serious Mr. DeNolf's crime, a sense of retributive justice cannot justify an otherwise unconstitutional punishment. And we would ask this Court to consider the treatment of Mr. DeNolf to be cruel and unusual for two reasons. First, the sentence and conditions of confinement at Poseidon Penitentiary violate contemporary standards of decency. And second, the state has shown a pattern of deliberate indifference to the risk of future harm to Mr. DeNolf's health. Now, Your Honors, in DeShaney v. Winnebago, as cited in Helling v. McKinney, this court said that when a state takes a prisoner into custody and deprives that person of the ability to care for themselves, the burden shifts to the state to provide for that person's basic needs, and to do otherwise strikes at the very heart of the Eighth Amendment. Now, Your Honors, as far back as 1890, in the case of In re Medley, cited in Madrid v. Stillman, this court recognized that solitary confinement was likely to lead inmates to serious mental deterioration, even irrevocable psychosis. In the Medley case, a moratorium on human interaction and cramped conditions led some inmates to comatose states, others to violent outbreaks, and others to suicide. More recently, the Seventh Circuit in Davenport v. de Robertis, also cited in Madrid, held that there's a growing academic and social consensus that solitary confinement can destroy a person's mental health.
Does the state use the same confinement for protection?
Your Honor, the state has 6 forms of solitary confinement, according to page 6 of the record. Protective custody within a prison is a different type of solitary confinement from the one Mr. DeNolf is experiencing, which is solitary confinement as a result of his sentence.
But would you make the same argument about protective custody?
Your Honor, we have no details in the record on the conditions of confinement in protective custody or how long inmates are required to serve in protective custody, although the record implies that it's an administrative decision made by prison officials to protect an inmate from harm rather than a sentence imposed for the gravity of an offense.
Should there be evidence that the petitioner or someone like him would have a tendency to be harmed? In fact, demonstrated some mental illness or problem in their past, for there to be any concern about this?
Your Honor, I'm quite unsure of your question, but if you're considering the mental health harm...
Well, in the record it says that there was no evidence of any mental illness on his part, and shouldn't there be some evidence of that if we're going to be concerned about this type of confinement?
Yes, Your Honor. However, there is evidence in the record of the mental state of Mr. DeNolf. It's on footnote 2 of the record on page 3, where expert witnesses for both the petitioner and the state concur that after 3 years in prison, Mr. DeNolf is already exhibiting 2 signs of major depression.
Is this like a constitutional injury, or is this something you think he had going in? Is this the injury that you think caused as a result of the constitutional violation?
Yes, Your Honor. We're contending that the conditions of confinement are likely to lead to a harm to Mr. DeNolf, which is significant enough to warrant Eighth Amendment scrutiny.
Is this a new standard from the Eighth Amendment standards in this context before that you're asking for?
Not at all, Your Honor. This court held in Wilson v. Cedar, as cited in Hudson v. McMillian, that deprivations of the minimal civilized measure of life's necessities violate the Eighth Amendment.
That's a general statement, but factually speaking, how similar is that to what we're talking about here?
Your Honor, we have no cases on our record from the Supreme Court dealing with mental health specifically in the facts. However, in Rhodes v. Chapman, this court held that when the conditions of confinement undermine the mental or emotional state of an inmate without penological justification, this violates the Eighth Amendment. And the Northern District of California in Madrid versus Gomez looked at a case that was very similar to ours, solitary confinement for prisoners in Pelican Bay State Prison in California. Now, in that case, the Northern District ruled that that was unconstitutional because of the mental health harm to individuals in solitary confinement, and that the state had not done anything to prevent against that harm. And this court, in Estelle versus Gamble, also cited in Helling, said that when there is a substantial risk of harm to an inmate, and the state is deliberately indifferent to that risk, that constitutes an Eighth Amendment violation because it's an unnecessary infliction of pain.
Didn't he have depression before he came to the prison?
Your Honor, the record on footnote 2 specified that he had a family history of depression.
Okay, and so what's to say this isn't a natural occurrence of his family history as opposed to what was imposed as a sentence?
Well, Your Honor, the Northern District in the Madrid case found that people with family histories of mental illness placed in solitary confinement were at a significantly higher risk of serious psychological disorders. In fact, they likened it to placing an asthmatic in a room with little air to breathe. Now, if this court's standard from Troke versus Dulles is punishments which violate human dignity, a person without their sanity cannot possibly have their dignity in any meaningful constitutional sense.
Are you implying he has no sanity because he's depressed?
Your Honor, we're arguing that the conditions could lead to Mr. DeNolf's insanity. And admittedly, right now, he's showing only the early signs of depression. But as this court stated in Helling, it's not about the harm being fully actualized at the moment, which determines whether or not this court can intervene, but rather whether or not there's a substantial risk due to his conditions, and the state has been deliberately indifferent to that risk.
Could it be argued that anybody that is confined for a long period of time in the penitentiary, whether they're in solitary or in general population, could be depressed?
It's possible, Your Honor, which takes us to the second component of any Eighth Amendment challenge, which is the state's response to the risk. A simple medical risk may not be unconstitutional, but when the state knows of that risk and then takes no measures to ameliorate that risk, that's the type of wanton or unnecessarily infliction of pain that this court talked about in Gray versus Georgia.
Is this going to turn the whole concept of the SHU, as we call it, segregated housing units, is that going to turn it on its head? If you start interfering in the prison, because they have their own considerations, as the Chief Justice was mentioning, that they have to balance in this regard, right?
Absolutely, Your Honor. And you're correct that this court has given deference traditionally to states and administration. But this court also held in Cruz versus Beto, cited in Brennan's concurrence in Rhodes, that once this court determines that the harm or potential harm to an inmate is so significant as to constitute something that would be unconstitutional, this court has broad authority to regulate prisons to make sure that the conditions are constitutional.
How can you argue that there's substantial risk and that the prison administrators do nothing in the face of that risk when, as here, you have 24-hour security guards who are monitoring them, who have the right to recommend them for mental health professional evaluation. They have 3 on-staff mental health professionals and a variety of other things that are available to deal with prisoners who have been referred for consultation with a mental health professional.
Your Honor, there are 4 problems with the prison system that fail constitutional minima. The first is that Mr. DeNolf was not provided a pre-screening, either mental health or for his physical health, before he came into the prison. It's almost the definition of deliberate indifference for the state to not know his condition before they give him certain conditions. Moreover, the state, the prisoner, even though he's overseen by prison guards, page 9, paragraph 3 of the record indicates that these prison guards have no training in mental health issues whatsoever, even though they're solely responsible for referring Mr. DeNolf to mental health experts if his depression were to worsen. Moreover, they're not allowed to interact verbally with Mr. DeNolf. So if Mr. DeNolf were to suddenly contemplate self-harm or even suicide, it's unlikely that the guards are adequately trained to refer Mr. DeNolf. And third, even if they did refer him, there's no evidence in the record that there are actual psychiatrists on call at the Poseidon Penitentiary. Page 9 notes 3 mental health experts, but they only have a minimum of master's degrees in social work, not psychiatry. And there's no intensive psychiatric care available on site, and Poseidon refuses to transport any prisoners off-site. Combined with Mr. DeNolf's almost total isolation from other humans and lack of any meaningful human contact, this comes close to what this court said in Farmer versus Brennan, was locking away a prisoner and letting the state of nature take its course. In this case,
Who do you think could be put in solitary confinement?
Your Honor, I see that I'm about to run out of time. May I briefly answer
You
your
may
question?
answer this, please.
Your Honor, we don't believe that solitary confinement placed on people with adequate mental stability, with safeguards protected around them, such as adequate medical care, adequate oversight, and meaningful human interaction, would lead to the type of harm here. But because Olympus has done none of those things on someone with a predisposition to mental illness, that violates the spirit of the Eighth Amendment. Thank you, Your Honor.
Any other questions? Thank you, Mr. Baldacci. We'll hear from the respondents.
Chief Justice, and may it please the Court. My name is Henry Filosa, and I, along with my co-counsel Rebecca Lynn, represent the respondent, the state of Olympus. I will be addressing the first issue, the constitutional soundness of the FBME as used by the state of Olympus. Your Honors, this case is about a non-invasive technology which held Mr. DeNolf accountable for his shocking violence while respecting his constitutional rights. For these reasons, we ask that this Court uphold the lower court's decision and deem the FBME constitutional for the following three reasons. First, the results of the FBME are not testimonial. Second, usage of the FBME by the state of Olympus is not compulsive in all situations. And third, the FBME is a reasonable test. On the first point, this court has a long line of jurisprudence holding that evidence obtained from the material body of a defendant is acceptable in court over Fifth Amendment objections. This dates back to Holt v. United States as cited by Justice Brennan's majority opinion in Schmerber v. California. In that case, the court found that it was acceptable for a defendant to be compelled to wear an incriminating blouse. And since then, the court has held that it is acceptable to withdraw blood by force from a defendant, to produce a handwriting exemplar in Gilbert v. California, to produce a voice exemplar in U.S. v. Dionisio, and to participate in a lineup, as in U.S. v. Wade, all three of which are cited in Doe v. United States. The FBME is simply a continuation of this trend, a test which gathers physiological evidence through...
I have a question. I know that we're not contesting that the reliability of this test is in the record, but is there not some subjectivity involved to interpreting the results of this test that would not enter into, say, a blood test? Could different observers reading the results have different thoughts about how he scored on it?
Well, Your Honor, there is no more subjectivity than other tests this court has found acceptable. For example, a blood test. The blood test in Schmerber doesn't say what the individual drank, where they drank it, or what they did after they drank it. It is only with that evidence combined with other information, such as the fact that they were pulled over in that state, that they were then convicted for drunken driving.
But any researchers would all come up with the exact same results under that scenario. And my question is, would they all come up with the same results under the test results that we're talking about here, which sounds like implicitly there might be some subjectivity involved. I guess I'm just not as familiar with the way the test works.
Yes, Your Honor. On page 3 of the record, it is stipulated that both parties agree that the test is 100% scientifically accurate. If an individual has seen the image that is presented during the test, that means the test will always return a positive result with no false negatives. Now, the interpretation of that result is left up to the jury along with other evidence, which was presented in this case. But the evidence is not of testimonial nature, as it falls in line with the court's past jurisprudence.
Let me ask you a question here. The opinion of the Supreme Court of Olympus appears to be saying that these are only electrical impulses, and they're the same thing as blood coursing through someone's veins. That's the way I take it. But the electrical impulses going through one's brain, aren't they what triggers speech? Aren't they communication then?
Your Honor, it is true that delicate electrical impulses on a granular level control thought, but the FBME is not returning Mr. DeNolf's active thought or consciousness. It's returning the presence of a simple memory. This is why on page 2 of the record, it is commonly referred to as brain fingerprinting. It is as if the image leaves a fingerprint on the mind. It's analogous to as if there was a specific chemical found at the crime scene, and they withdrew blood from Mr. DeNolf, which contained the same chemical. There was no testimonial component that was added, as Justice Brennan referred to in Schmerber when he determined that the blood test had no testimonial component added to it by the defendant.
Just quickly tell me what the difference would be if they held up pictures before Petitioner and said, do you recognize this? And he was told to say yes or no. But here they're taking brain waves, which one could argue, of course, is the same thing of saying that he recognized.
Your Honor, when analyzing whether an evidence itself is testimony, the end result of it is irrelevant. In the case of Schmerber, the police could ask him, have you been drinking, are you drunk? And his answer would be testimonial. But when they got the same answer from his blood, his material evidence, it was non-testimonial. In this case, similarly, though they could have obtained the same answer by asking him, have you been to this room? And they got the same answer by using the technology, the method by which it was performed does not bring it into the realm of testimoniality and Fifth Amendment protections.
I mean, isn't this effectively worse than verbally questioning him? Because once the image is placed in front of him, he cannot consciously decide, he cannot tell his mind to not respond to the image by demonstrating brainwave activity that shows he has a memory of the image. So he has no way to consciously override that brain activity.
That is true, Your Honor, and that puts it on the side of blood test and Schmerber. Justice Brennan noted that one of the contributing factors to his decision, the court's decision, was the fact that Mr. Schmerber could have no effect on the outcome of the blood test. His participation was almost irrelevant. Furthermore, however, even if you find that the results are testimonial, as this is a facial challenge, the petitioners must prove that it is compelled in all circumstances. However, it has long been this court's jurisprudence that the Fifth Amendment is not a self-executing right. And in this case, Mr. DeNolf did not affirmatively execute his Fifth Amendment right when he voluntarily underwent the test, as Your Honor noted.
Okay, that's the question, though, isn't it? Voluntarily. Do you think he, coming up with this warrant, he actually consented to go with them? The circumstances are a little murky there as to whether or not he agreed to go with them. I know you all probably don't agree about that.
Well, Your Honor, on page 4 of the record, it does note the warrant was obtained, but it doesn't say if the warrant was shown to Mr. DeNolf. And as we're examining this on a facial level as to what is going on in the general state, we can imagine a hypothetical where one was not shown to the individual and they went along just on.
Did they tell him they had a warrant?
Your Honor, on page 4 of the record, it is silent as to whether he was told about the warrant. So in the hypothetical that he was not told about the warrant, he went along voluntarily. Now, in Garner v. United States, as cited by Commonwealth v. Noble, this court wrote that even if in a compulsive situation, if the individual does not make a valid claim of their privilege and they then testify, the government has not forced them to incriminate themselves. There are only two exceptions to when Fifth Amendment rights are self-executed, laid out in Minnesota v. Murphy, as cited by the 10th Circuit's opinion in U.S. v. Von Buren. In that case, the two exceptions are, first, a custodial interrogation, and second, the threat of significant penalties. Now, on the second point, a warrant could constitute a threat of significant penalties. But imagining the hypothetical, to say that Olympus does seem to be going through, where an individual simply asks, hey, will you come down to the police station and then will you please come to this FBME?
Was he free to go?
Your Honor, there's nothing in the record to indicate that Mr. DeNolf was ever told he was under arrest, ever put in a locked room, or ever handcuffed. In fact, he walked along with the two officers several blocks and was never told he could not leave. Now, the first exception that laid out in Minnesota v. Murphy, which is what he raised his Fifth Amendment objection on, was that of custodial interrogation. In that case, he was questioned during a parole hearing. And this court ruled that a parole hearing, an event where an individual is expected to show up at a required time and meet with an individual who determines whether they remain free or return to jail, was not custodial interrogation. It would appear that if on one end of the spectrum is an individual under arrest in police custody, and on the other end of the spectrum is an individual in a parole hearing, that an individual who is asked to and voluntarily comes down to the police station for questioning would fall on the other side of a parole hearing, thus making his participation in the test voluntary. As noted on page 5 of the record, Mr. DeNolf underwent the test silently, displaying no outward signs of distress or discomfort. And this finally leads to the third point, the reasonableness of the test. In Schmerber v. California, after analyzing and finding that it was not testimonial, they still had to find that the test was reasonable, meaning that it was conducted by trained professionals in a medical setting and carried little risk of trauma or pain. As noted again on page 5 of the record, Mr. DeNolf underwent it with no distress, and page 2 of the record notes that it simply involves the application of electrodes to the head. And on footnote 3, it notes that the entire FBME process took 30 minutes to complete from start to finish.
How does it compare to a polygraph?
Your Honor, the comparison to the polygraph is not applicable because the polygraph is trying to coerce an individual into telling the truth by using the results of the polygraph to affect their verbal testimony. But as the results of this are not testimonial, we ask that this court uphold the lower court's decision and rule it constitutional.
How about a penile plethysmograph, which we discuss in U.S. v. Weber?
Your Honor, may I answer?
You may answer.
Your Honor, the Ninth Circuit in U.S. v. Weber found 2 reasons that the plethysmograph was unacceptable, which should not apply today. The first was its lack of scientific accuracy. As experts testified, it is only around 50% accurate and susceptible to faking. The second was the physical invasiveness of it, as it involves the placement of devices on the individual's genitalia and requiring them to physically pleasure themselves. As noted, this test does not carry any level of intrusion near that. Thank you, Your Honor.
Any other questions? Thank you, Mr. Filosa. Ms. Lynn, we'll hear from you. Please.
Chief Justice, Associate Justices, and may it please the Court. My name is Rebecca Lynn, and I, too, represent the respondent, the state of Olympus. I will pick up the second issue, how the use of solitary confinement as applied to Mr. DeNolf does not violate his rights protected under the Eighth Amendment. Your Honors, this case is about upholding the sanctity of the judicial system and ensuring that criminals are punished for their crimes. Therefore, we ask that this Court uphold the decision of the lower court and find the use of solitary confinement as applied to Mr. DeNolf to be constitutional for 2 reasons. First, this punishment is not cruel, as it is not deliberately indifferent to a future harm. And second, this punishment is not unusual, as it is prevalent throughout the entirety of the United States. Turning to my first.
Well, with regard to that comment, isn't Olympus the only place where this type of confinement is something that is done as a consequence of the crime that they committed as a part of the punishment rather than because of something that happened while they were incarcerated?
No, Your Honor. According to page 6 of the record, Olympus is the only jurisdiction that gives judges the discretion to sentence people straight to solitary confinement.
Didn't the judge say that he got the solitary confinement because he tortured the victim?
Yes, Your Honor.
Hadn't 20 states already abolished solitary confinement?
No, Your Honor. 40 out of 50 states, including the federal government, still practice solitary confinement. 20 states have made some sort of reform or abolished solitary confinement, but the majority of states in the United States still practice it, making it a usual punishment. By no means is what Mr. DeNolf received an unusual one, and if we look to footnote 32 of Chop v. Dulles, the court notes that the definition of unusual should be the ordinary one.
But how do you square the penal institution side of this, which you have to do in an Eighth Amendment analysis, their interest in doing something like this? How do you find those when, in fact, they're never even considered because he's already going there by virtue of the judge's sentence? So where's that consideration, and why does that not take a detour from our usual discussion of Eighth Amendment prison conditions?
Your Honor, if I understand your question correctly, the principle of federalism is essentially what's important here, that this court has a long-standing history of judicial deference to the state and allowing it to make its procedures. And here, the state of Olympus has decided that by allowing judges the discretion to sentence people straight to solitary confinement is the discretion that should be given to their judges.
But aren't we really disregarding one of the most important pieces of that analysis in Eighth Amendment cases, which is what's the prison's interest in handling them so harshly? And really, there's none here because the judge decided that up front.
Your Honor, these legitimate penological purposes are not only contained in the sentence, but also the punishment itself, and the state does have legitimate penological purposes here. In Harlan v. Michigan, the court outlined 4 possible ones: retribution, deterrence, incapacitation, and rehabilitation. Although they outlined 4, they noted it only needs to serve 1. And this case does exactly that. It serves the purpose of retribution. Mr. DeNolf committed a heinous crime of murdering and torturing a woman, and as a result, he was sentenced to the normal punishment in the state of Olympus. He was sentenced to solitary confinement.
But so did, there are other inmates in the prison that committed serious offenses, and they're not being punished as harshly as Mr. DeNolf because they don't suffer mental anguish, mental illness, and it's making him worse.
Your Honor, the issue of whether or not Mr. DeNolf has a mental illness right now is unclear. The record notes on page 3, footnote 2, that Mr. DeNolf has simply shown symptoms of major depression, and that these symptoms include a lack of appetite and an inability to sleep. Symptoms that are common to many people who are sentenced to other similar punishments.
If the symptoms were more serious and the diagnosis was more profound, would the state move him?
Your Honor, that would definitely be a possibility. If Mr. DeNolf had received an official diagnosis that right now he had been decided and declared to be mentally ill, it's possible that the state of Olympus could then move him. However, that's not the case. And this brings me to my first point, that this punishment is not cruel because there is no deliberate indifference to a future harm.
Isn't it deliberately indifferent when you don't assess the mental condition on the front end of the inmate before you subject him to this type of confinement?
No, Your Honor. Poseidon Penitentiary has taken many reasonable steps in order to ensure that prisoners like Mr. DeNolf receive the adequate mental health care that they need. For example, on page 9 of the record, it notes that there are 3 full-time medical officials on call who can be used to help Mr. DeNolf. And the ratio in Poseidon Penitentiary is about 1 to every 200 or 220 for prisoners to medical officials.
But the way inmates get access to those professionals is the guards would have to bring it to the attention of the professionals, correct?
That is one way in which they could receive mental health care.
What are other ways?
The petitioner himself could ask for help, and the record is silent about whether or not he's even done so.
Who would the petitioner ask when the guards are not allowed to talk to him?
Mr. DeNolf is allowed to write a letter, a written statement requesting help. And if he had done so, he could have received it. At Poseidon Penitentiary, the way in which mental health can be triaged is through 2 ways. As Your Honor had noted, by the guards noticing it, and they do watch him through 24-hour surveillance.
Does the record not show that he has experienced some mental illness, evidence of mental illness at this time because of his confinement?
No, Your Honor, it does not. The record simply states on page 3, footnote 2, that he suffers from a family history of it, and that he shows symptoms of major depression.
Okay. So when the symptoms show up and somebody perceives it, could it not be too late to help this individual? Mental illness is a very complex thing. So do we just automatically say we're going to fix you up and move you to the general population? I mean, this may not be a remedy. Would you not agree?
Your Honor is correct in noting that this ambiguity of the future harm is what's at question today. And to answer your question, we should look to the 3-pronged standards set forth in Helen v. King. First, there must be an objective harm. Second, there must be a subjective harm. And third, it must be a harm that society is unwilling to tolerate. The portion to which Your Honor is noting is whether or not it's an objective harm. Now, counsel for petitioner has tried to claim that because Mr. DeNolf has shown symptoms of major depression, that this is enough to warrant it to be objective. However, in Helen v. McKinney, the court noted that when there are mitigating steps that are taken, that this objective harm can be lessened, that it no longer becomes objective because of measures that the state has taken. And here, Poseidon Penitentiary has taken many reasonable steps to ensure that Mr. DeNolf can receive the help if he needs it.
But do you not ignore the fact that we as a society know, statistically, that approximately half of all the inmates in the United States suffer from some form of mental illness that have been incarcerated?
Your Honor brings up a great point. 50% of people who are incarcerated do suffer mental illness, and this is not unique to those in solitary confinement. If that's were the case, if we were to rule that because everyone has a mental illness and therefore it's unconstitutional, that would include the 50% of people in the general prison population as well. That we'd be setting a standard in which this court would be holding that simply anyone, that most people in our prison system are facing cruel and unusual punishments, and this is not what we want to be doing here today. Rather, we want to be evaluating that for Mr. DeNolf in particular, does he suffer a harm that's both objective and subjective, and whether or not that's a harm society is unwilling to tolerate. And the point that Your Honor has brought up has shown that, unfortunately, it's a harm that society is willing to tolerate. Now, I'll turn to the...
If he had a physical illness, wouldn't the state move him someplace to make that better?
Yes, Your Honor. If he had a physical
Why
illness,
is-
they would provide a doctor to help him.
Why isn't mental illness the same?
Your Honor, it is similar, and if Mr. DeNolf did have a mental illness, he could seek mental health care. He simply would have to ask, and Poseidon Penitentiary could use one of its on-call mental health professionals to help him. It's very similar and exactly analogous to what would happen if he had a physical harm.
How would he know? He might not know he has the mental illness any more than he might know that he's got an appendectomy. He wouldn't know to ask. How does the penitentiary deal with those situations?
Your Honor, unfortunately, the Poseidon Penitentiary can only do what's reasonable. It's impossible to ask Poseidon Penitentiary to read Mr. DeNolf's mind and to see whether or not he needs help in that exact moment. It provided very reasonable recourses that Mr. DeNolf can use. If he thinks that he needs help, he can ask for it. And he's being monitored 24/7 by guards to see whether or not they think that he needs help and can triage help if he needs it.
I just want to go back to one point, and that is this idea that we're looking at the interests of the state versus the interests of the prison. We are really just centering on the right of the state courts to make these sentences. It has nothing to do with what might benefit the prisons, right? I mean, I'm just trying to see where it is and what are the factors that would indicate the courts should have such power and such, what enhances that? What supports that authority for them to just say you're going? And the prisons go along with it.
Chief Justice, I think
You may answer.
Your Honor, we can see that the state has legitimate reasons for putting Mr. DeNolf in prison and placing him in solitary.
And you're talking about the courts?
Yes,
Right.
Your Honor.
Not in prison.
Yes, Your Honor. But we can also see that the prison has reasonable reasons for why the institutions it has in place are in place. And those are to ensure that if Mr. DeNolf needs help, he can receive it. And thank you. Therefore, we ask that Your Honors uphold the decision of the lower court and find this to be constitutional. Thank you.
Any other questions? Thank you, Ms. Lynn. Mr. Engle, will hear rebuttal? No? You have 3 minutes remaining, I believe.
May it please the court. The FBME insults this court's respect for the inviolability of the human personality and violates what Justice Stevens and Doe called the right of every person to the security of his own thoughts. Your Honors, 2 points of rebuttal. First, Respondent contends that the FBME produces physical evidence rather than testimony. However, this court ruled in the case of Gilbert versus California, as cited in footnote 2 of Justice Brennan's dissent in Doe, that the forced production of physical evidence involves no intrusion into the mind of the accused. The FBME produces the same kind of evidence as if Mr. DeNolf had been forced to testify against himself at trial, and this evidence came from the exact same source. The only difference is that the state in this case denied him the option to remain silent. A more egregious offense to the spirit of the Fifth Amendment can scarcely be imagined. If this court accepts Respondent's theory, this means that future accused can be compelled to take the FBME just like they must take a breathalyzer on the side of the road. This means that a suspect, though he tried with all his might to invoke his Fifth Amendment right, will be handcuffed and escorted by officers of the law to take a test which reveals the contents of his mind. Turning to the second point of rebuttal. As Your Honor, Justice Garcia pointed out, Mr. DeNolf, in many instances, in fact, we contend in every instance, due to the inadequate training of the guards, will have to request assistance for his mental health himself. And this court has found that people who are suffering mental illnesses oftentimes aren't competent to recognize that they have this mental condition or to request it. And this is made even more difficult by the fact that he's not permitted any kind of verbal interaction with his guards. The Northern District of California found in the case of Madrid versus Gomez that to take a mentally ill person and place them in solitary confinement is the equivalent of taking an asthmatic and placing them in a room with little air to breathe.
But prisons can't be hospitals.
Your Honor, that is correct, but that also does not mean that the state can show deliberate indifference towards the apparent needs or the future needs of Mr. DeNolf. The fact that they placed him in almost uninterrupted solitary confinement for the next 30 years, with no medical pre-screening and no regular mental checkups, is a kind of deliberate indifference that rises to the level of criminal recklessness. Your Honors, In the 11 minutes that I've been speaking to you today, I've had more face-to-face human interaction than Mr. DeNolf will have for the next 30 years. If the sanctity of human dignity means anything, it is that this sentence is cruel, inhuman, and ultimately unconstitutional. Thank you.
Any other questions? Thank you, Mr. Engle. That concludes the argument in DeNolf versus the State of Olympus, and the marshal will adjourn the court.
Good job. You're great.
Thanks. Chief Justice of the Texas I just I'm so tired. That's not my word. One job was more ready that one.
By the way,
Better set of
yeah, we all like got to restaurant, and then before we gotta go back.
Thank you so
Yeah, I know, that was perfect. Just put a little more on it. It lets everybody I'm sure you can't break No, go for it. Congratulations.
Please be seated. Well, as we were warned, it was an excellent presentation by all, but we thought we'd give you a few comments. Judge Garza, let's start with you.
I thought you were all very impressive. You're all going to be inspired to be lawyers. You're all going to be great attorneys, great advocates. So you did an outstanding job. So congratulations to you. Come on board.
Jane?
We have a lot of prisoner litigation in federal court, and spent a lot of my career looking at these issues, and I kept picturing, they got a case here about the shoe, that segregated housing, and that is something that we have heard about for years. So I found it very interesting to hear you all argue different sides of issues that we have been listening to for a long, long time, and really, really do affect people's lives on a regular basis. So thank you for your excellence in advocacy.
Okay.
You all were really amazing. We were discussing with the Chief Justice whether he would waive the requirements for the bar for you all, but we're not able to do that. But we were really impressed. I'm a judge over a trial court, and I would be delighted to come out to this kind of advocacy every day. For each of you, I was thinking of one word, and I'll just go down completely unflappable. Unflappable is what I came away. Creative advocacy for you, really just in responding to some of the difficult questions that we were pressing you with. You all have a tough legal position. The more sympathetic legal position, I think, is over here. But the position notwithstanding, the advocacy was just impeccable on both sides. For you, it would be organized, and a second word, deliberate. You're very deliberate with responding to questions. And the word that just keeps coming to mind for you, Mr. Engle, is just amazing. I mean, really, just all around every category. I just thought you all did a fantastic job, and you were particularly amazing.
Douglas?
Thank you. Excellent argument. You would rank among some of the very best that we see in the Texas Court of Appeals. Just down the street, the ways. Well done. I have a couple of comments about, try to keep it to one for each of you. And we can always improve, and you guys are just extraordinary. You might think about the speed of talking. Depends on where you're from. But I grew up in the Midwest, and I get rolling pretty fast sometimes. Just have to think about tempo, and you're anxious. That comes with experience. You've obviously supported yourself very well. Responding to questions, you did a great job. And you got to always keep that in mind. Don't dodge it. Respond. If you don't know, say you don't know. But you did an excellent job on that. I would say, Mr. Engle, I like that closure that you've had more interaction with us than the petitioner's going to get during his sentence. I would be careful on saying that this process insults the court's respect and so on. I got a little twisted on that, but I thought your last statement was very emphatic. And I would say, and I'm going to butcher your name, I apologize, but Mr. Filosa, excuse me. Yes. I thought it was great to this discussion about brain waves and blood are similar, and I think you came back on that and framed that very well. You were a little anxious sometimes. But Lord, when I argued on appeal, I was always anxious. Regardless of how many times you do it, if you don't have a little stuff going in your stomach, you're really not healing. Ms. Lynn, I thought it was excellent to come back with that objective harm argument when we started to be concerned about the determination of mental illness and so on. So, outstanding.
And one last thing, I'm sorry, Chief. I just want to tell you that you all seemed like you really believed in your cases.
Yes.
You did, more so than what we see, with the problem. You all are so used to it. But I really thought you were so upset about the petitioner and segregated housing and the way you've been treated, and that, in fact, it's okay. It wasn't that bad. The case is supported, and I appreciated that. That's one of the keys, believe in your case. So, sorry.
Judge Clinton?
As a trial court judge, I have to say your knowledge of the facts and the grasp of the law was very impressive. All of you did an excellent job. I can understand why you made it to the finals. So regardless of the outcome, congratulations. You have extremely bright futures ahead of you, and we all anticipate seeing much more of you.
I think the biggest enemy of litigators is not being prepared. You've cleared that hurdle. And once you get past the hurdle of preparedness, then it becomes ease of communication with the court. So the stakes are high. You're in the finals, in the national competition. I get that. It would help a little bit if you calm down in the beginning instead of waiting to get into your argument. I loved your transitions. I loved the answers, taking the answers to taking the questions, answering them, and then moving to the next step. Y'all did that like it was mental judo. It was really amazing to watch. You're doing a great job. You have great futures.
And I'll just echo what others have said, that preparation is so key to presenting a case in real life, not just here. You just got to know it backwards and forwards. And then you have to believe it. You have to, if you've got doubts about it, then those will come through. And so you really got to believe your position, and you all have had to argue both sides. So that makes it harder sometimes, but maybe it makes it easier too, because you can see the other side, which is the third thing, and that is not everybody sees it your way. And so you got to try to figure out where the holes are, what the weaknesses are, and address them in a very good way. But yes.
Go ahead.
Yeah.
Well,
no, I'm done. Yeah.
Okay. I was just going to say, all of you have heard the mantra in real estate sales. It's about location, location, location. This kind of profession, what we do, it's about preparation, preparation, preparation. When you get tired, you just got to reach down and you've got to happen. You guys know that. Just keep that in mind forever.
I know I speak for my colleagues when I say in a few years, if you continue on this path, come see us. We would love to have you in court. It's a great privilege for us to be part of something that is so instructive and goes so far toward building careers and lives, and it was a pleasure to be here. We're especially glad to be on the campus of the University of North Texas Dallas College of Law, which has worked really hard to do a lot of good here for legal education in Texas, and we're very proud of it.
Chief, may we know where they're from?
Yeah, if that doesn't... Yes. Mr. Filosa?
We're from the University of Chicago.
Wow, great place.
We're from Patrick Henry College.
Mm-hmm.
Congratulations.
Well done.
Wonderful.
We'll take some pictures.
You would please thank me and all the chief justices for their time today. I'm going to take one. I think we got another round.